all judges are members of the NBA. They grew from the NBA. So before you become a judicial officer, you're first and foremost a lawyer, unlike some civil law countries like France, where you choose the path you want to follow. If it's the judicial path, then you go to the magistracy and rise there. But if it's the practice part, you also make your choice and go there. So of course in Nigeria it's fused, and both have the same source, have the same roots. So you see the symbiotic relationship between both the bar association, the bar, and the bench. It's two sides of the same coin. So whatever affects the judiciary affects the NBA and the bar, and also what affects the bar affects the judiciary. And so the NBA has a critical role to play in anything impacting on the judiciary. And don't forget that lawyers are the ones who go to court to argue their cases before the judges. So it is what the lawyers bring forth that the judicial officers pronounce on. So anything that in terms of progress, in terms of affecting the judiciary, the bar is central to it all. And there are many things that because of the nature of their jobs, the judiciary judges cannot speak up for themselves. So the bar has to speak up for all the challenges they face, all the issues that bedevil our judicial process. We are really intertwined. So we have to speak up for all the things that bedevil the bar. They are not allowed by virtue of their calling to speak and to put their things forth, at least not in public anyway. And many of them don't have those channels of communication with the executive or the legislature. So in a sense, the bar is the go-between between the bench and the public on one hand, and the bench and the other arms of government on the other. So yes, we do. That's a critical role that the bar has to play in it. But I also think the judiciary should also save itself. Confidence in the judiciary is not as high as it should be. Recall that after the 2023 elections, the judicial interpretation was deemed to be narrow, to be restrictive and constrictive. And I've read quite a number of the judgments coming out of those elections, and you see that as the judges said in those judgments, we only decide cases on facts and law as we see them. So interpretation comes into play. Everybody, for example, believed that iRev and the smart card reader or other technological device, in this case the BVAS, was an integral part of our law. But in interpreting the things, the judges said no, it is not. So that was controversial, very controversial, and that's one of the thematic areas that will be discussed at the NBA conference on electoral reform. But you also have the more recent judgment, which people say is the local government, I think it's a misnomer, local government autonomy judgment of the Supreme Court. Some people feel, well, maybe that's a way of taking a populist stance in giving life and effect to the Constitution. But some of us are a bit critical about that judgment in the sense that it did not overrule an earlier judgment of the Supreme Court, the case of Attorney General of Lagos State against the Attorney General of the Federation, where it validated the existence of the joint account in accordance with the letter of the Constitution. And it will appear, and some critics say, that the judiciary amended the Constitution by that judicial pronouncement. And when you look at the literal words used in the Constitution, you find out that there's some merit in that argument. But the judges said they were trying to give purport to the intendment and the spirit of the Constitution, and they went beyond the letters. The issue is that how will it end? How far can we go in that regards? And when we read the Constitution, we see that there shall be a joint account in the states and local governments, and which shall be called states local government joint accounts. By judicial interpretation, that no longer exists, and that seems to have done violence to the plain language of the Constitution. So, while it's populist and it's well received in many quarters, so pay heed to it. There are issues of enforcement of such judgments, because it can be very challenging. So I'm pleased to note that the Attorney General of the Federation has set up a committee to ensure the transitional arrangements and enforcement and things like that. So the judiciary has to reflect in certain ways. There's positivism, there's activism, but I don't know how far it can take us. Unfortunately, when judgments are popular, they are hailed as the last hope of the common man. Sometimes they're not as popular, they're crucified. So those two judgments, I think history will take a closer examination of those two judgments. They're two of the most controversial judgments of the recent era coming from the Apex Court. For a long time, I think conversation will continue as to the correctness or otherwise of both judgments.